Yes, Mr. Secretary.
May it please my lady and my lords, before I start by introducing the parties, this is a public hearing, and although I will try, and I'm sure my learned friends will try, to anonymise as we go along, just in case we slip, I wonder whether my lady and my lords would consider making the usual direction.
I will certainly make the usual direction, and if I can just... Yes, we are being live. So I was just looking for my trusty button. I have there's a 90-second delay, and I have got a pause button as well, if I could find it.
Thank you, my lady.
So there it is. So please, yes, everyone will do their best. Unfortunately, I think the nature of the arguments is such that it's easier than in some cases, I think.
Indeed it is.
Now, if I can tell you before you start, Mr. Setright, that we've taken the opportunity of reading extensively into the papers, and not just the skeleton arguments and the judgments, also we've dipped into the authorities also, so you can take that as read. I presume that you've worked out together your timings. As you know, we aimed to sit as soon as we could at 10, with a view to completing all the arguments today.
Subject to unforeseen events, having canvassed the position with both my learned friends, we are pretty confident that we will finish within the day.
Yes, well, if we could make that more concrete, I'd be obliged.
How could I refuse, my lady? So, my lady, shall I proceed to open?
Certainly, unless there's any other housekeeping matters.
There is not.
No, thank you.
So, my lady, in this appeal, I appear together with my learned friend, Miss Anita Guha, the appellant, who is the paternal grandmother of the female child, who I'll call H, who was born on the 22nd of September 2009 and who is now aged 13. The grandmother is in Tunisia. She's watching these proceedings on the video link,
yes,
but unfortunately without the benefit of interpretation, so what she gets from them will be relatively limited. The respondent local authority, and I can name it because it's named in the published judgment,
yes,
of Mr Justice MacDonald, is the London Borough of Hackney, and it has instructed my learned friends Mr Mark Toomey, King's Counsel, and Mr Edward Lamb, and all counsel thus far appeared in both the hearings before Mr Justice MacDonald, so there's continuity. That doesn't apply with my learned friend Mr Kieran Pugh, who has stepped in on behalf of the child instructed by her Kafka's guardian.
Brings the fresh eye, thank you, Mr Pugh.
And my lady, and what I'm going to do from here on in is to bear very well in mind that the court has read, among other things, our skeleton arguments, and therefore what you will not need or benefit from is a line-by-line traverse.
No.
So, bearing in mind it's a public hearing, I'm going to open it in outline.
Yes, of course.
I'm going to go to the background, but only in outline and to the salient points. And then, I hope, concisely, in all the circumstances, to the arguments. In doing so, I may elaborate on some points in the skeleton,
of course,
and I may also essay some responses to the other parties. But the timings that we have canvassed between ourselves will allow me a relatively generous opportunity, unless I am profligate this morning, which I won't be, I hope.
Or we're outrageously interventionist.
No, that's not possible, my lady. There will be time for me to reply,
yes,
and I will see what balance to adopt. So, my lady, this appeal, my lady and my lords, this appeal, which includes consideration of a respondent's notice from the local authority, relates to issues about the jurisdiction of the English court to hear public law proceedings in respect of H, which arise out of successive determinations by Mr Justice MacDonald, made principally in his judgment dated the 29th of July 2022, page 346 of the model, but followed through in a second judgment dated the 16th of January 2023, which starts at 393. 3. Permission to appeal was granted on the 6th of April on the 2 grounds asserted by the appellant. Directions were given to a tight timetable in which the local authority issued its respondent's notice. There's nothing from us in writing in response to that. That was a relatively inevitable product of the timing, but I don't think anyone, least of all the court, is likely to be disadvantaged by that, bearing in mind the nature of the respondent's notice. The courts had skeleton arguments from the 3 parties. The case, having been listed on the 4th of May, was then delisted for administrative reasons, and after that the court was invited to and gave leave for an intervener, the International Academy of Family Lawyers, to provide written submissions, and the court has those prepared by Miss Jacqueline Renton, Miss Charlotte Baker, and Mr Frankie Sharma, and I will deal with those also in my remarks this morning. They came too late to be included in the appeal bundle, so they come in a separate bundle which hopefully everybody has.
Yes, we all have that, thank you.
And, my lady, the factual and procedural matrix of the appeal is set out in the skeletons and in the judgments. In a way, ground 1 is a very straightforward ground, because however it and the opposition to it are dressed up, the question in ground 1 is, what is the relevant date for consideration of habitual residence to determine whether or not there is a jurisdiction to hear public law proceedings, taking it that the 1996 Hague Convention applies, for that is the premise adopted by Mr Justice MacDonald in reaching his conclusion. The conclusion that he reached was that the relevant date was not, as accorded with the common practice in this jurisdiction for many years, query, and I'll come to that in the submissions, because of the influence of Brussels 2A, now defunct in effect, that it was not that, but that because there was no principle of perpetuatio fori, loosely translated, my lady, in practical terms, that notwithstanding a change of habitual residence, proceedings already in being continued to be valid, irrespective of the change. I hope that that is an uncontroversial approach to perpetuatio fori in context, that because perpetuatio fori did not apply, then the assessment of habitual residence would take place at the point of determination of the exercise. And that could, as in this case, which we have to say is not an example of good practice, quite the reverse, can be as much as a year after the institution of the proceedings which the issue is designed to validate. Mr Justice MacDonald's approach was not followed in a subsequent case heard by Mrs Justice Leven, who, for reasons which she gave in her judgment, and all these are explored in some depth in the skeleton, took the view that the English court and she would stick to the date of the commencement of the proceedings as the relevant date. That is fundamentally the issue in ground 1. It has considerable importance, arguably at least, beyond this particular case and its facts, because it's plainly important that practitioners and judges, first instance judges, have some guidance as to what the practice should be. I am conscious that although all the submissions including those of the intervener, are loaded with references to, in effect, policy, that the court is likely to decide this matter with an eye to policy, but as a matter of law. And this is an appeal, and we have to persuade the court that Mr Justice MacDonald, in this particular case, was wrong. So I bear that in mind, and I will, as well as referring to policy considerations, make my focus on law and what the court is required to do, and I'll endeavour to assist as much as I can. My lady, the second ground is one which probably is only reached, although that I suspect is not going to help my lady and the lords in the conduct of this appeal, unless the court knows better. It's probably only reached if I succeed on ground one, because if the applicant fails on ground one, then there was habitual residence referable to the local authority's care proceedings, and therefore there is a conventional, if I can put it that way without being slapped down by my learned friends, there is a conventional public law jurisdiction based on habitual residence in this case. But if the court is with us on ground one, then the question as to a residual jurisdiction in public law proceedings falls to be considered. Now, my lady and my lords know, and my lady in particular will be absolutely and utterly familiar with the territory. The jurisdiction to hear, the jurisdictional criteria for public law Children Act cases has been a much debated thing over the years. And Mr Justice MacDonald looked at what one might call the pre-Brussels 2A cases and the efforts by some judges to find that there was a jurisdiction, we say, my lady, a jurisdiction of necessity, in effect, to make public law proceedings work in circumstances where there is physical presence only. Matters then on the authorities proceeded to the, what I might call the Brussels 2A era cases, where notably Mr Justice Mumby, Sir James Mumby, President, indicated that physical presence was not enough. Those cases, of course, were coincidental with the 1996, but, my lady, as we know, the 1996 was in a locked box on a high shelf while we were an EU state. And so the number of cases involving the 1996 was minuscule, but there was a recognised sequence when looking at jurisdictional matters. Brussels 2A first, then the 1996, then the domestic law. This case looks, we think, for the first time, at what changes, if any, have been made to the approach. The view taken by Mr Justice MacDonald, it might have been technically obiter in the first judgment, because although he was firm in indicating what his decision would have been, it wasn't an operative decision, is that there is a physical presence-based jurisdiction, even if there is no habitual residence here, and there is habitual residence in what I, if I'm not careful, will call a third state, but should call a non-convention state, like the state in this case, which is Tunisia. That he refers to a common law jurisdiction, there are a number of routes to jurisdiction. The common law, my lady and my lords, means judge-made, effectively, and this court may have the opportunity to make some law in this hearing. The alternative is the inherent jurisdiction, and we will take, my lady and my lords, to what the Family Law Act, I've managed thus far to avoid speaking those words, the Family Law Act says about the jurisdiction for inherent jurisdiction cases, which are designed to place a subject child in the care of another person, which of course the Section 31 proceedings, we say, ultimately are designed to do. By ground 2, my lady, bearing in mind as I do that our submissions were described as bold by Mr Justice MacDonald, we seek to test that jurisdiction and to present a case which in effect says that the court should question whether that jurisdiction, or whether that jurisdiction other than for genuine emergency purposes exists. There is then the question of its exercise. Those are matters which were dealt with in the conclusion of Mr Justice MacDonald's second judgment, after he had dealt with two relevant issues: our adoption application, our return application as a non-convention adoption, and a conventional forum argument, both of which he found against us in. Would it be right to exercise the jurisdiction, nevertheless, if the correct finding was, as we maintain, that H had been habitually resident in Tunisia at a relevant date, which was the date of commencement of the public law proceedings? And we say that it may be that if you find for us on ground 1, even if you find that there is a residual jurisdiction, the matter should be remitted, and we don't take an objection to Mr Justice MacDonald being the judge to whom it's remitted, because he is nothing if not scientific, and we don't think there would be any bias of any kind, that Mr Justice MacDonald could then reconsider whether he should indeed exercise the jurisdiction that he said right at the end of his first judgment was he emphasised an open question. That's ground 2. The respondent's notice, which was much heralded in the assertions made on behalf of the local authority. Indeed, I rather think consideration must have been given to appealing that part of the judgment anyway, relates to the basic question of whether, particularly in a case involving a non-convention state, there was any need at all to go down the 1996 road. Mr Justice MacDonald gave a lengthy and detailed reasoned judgment to say why it was. That is something which we support. I will have something to say further about it, but nothing, I think, that is likely to be earth-shattering. So I am going to concentrate, if I may, on grounds 1 and 2. That, my lady and my lords, is a compact tour of the horizon insofar as the issues are concerned. If I can now turn, I hope at least equally briefly, to the essential factual background. Of course, the factual background is set out in the papers, and more than once I was pulled up by Lord Justice Thorpe, who reprimanded me for saying anything at all about the factual background on the basis that no one challenged the judge.
Well, I think that was in the days before live stream, and an understanding of the importance of transparency in the widest sense.
Just so, my lady, and so in deference to that, and hopefully not to trespass upon the court's patience, I'm going to deal with the factual background. My lady, the child concerned has undoubtedly had a very difficult life and history. She lived in France and suffered, in effect, the loss of both parents. She was found destitute in France and became the subject of public law proceedings in the court of Aix-en-Provence. Very sadly, her mother died. Equally, very sadly, her father, as is described in the judgment, was unstable, although he's continued, at least intermittently, to play a role in her life. H has a grandmother, a paternal grandmother, who lives in Tunisia. She is Tunisian. She, like many Tunisians, is bilingual in North African Arabic and in French. And she became engaged in the care proceedings in Aix, and first temporarily and then on a long-term basis, the court in Aix decided that the best placement for H would be with the grandmother, and with the full permission of the French court, that was done as a final order. And in 2018, those proceedings in France were closed. Plainly, the grandmother participated in those proceedings. Part of the condition on which the French court made its order was that there would be involvement not by the grandmother, but also by family members who were in Tunisia and by Tunisian social services who were engaged in this case. For nearly 4 years, H lived with the grandmother in Tunisia. My lady, what happened then is that in June of 2021, a visit was arranged by H to this country. We know that it was meant to be a short-term visit to see an uncle.
How do we know it was short-term?
Because in the evidence there was an arrangement within a matter of a week or two for her to fly to Nice. So she was going to go to France. There was not going to be any long-term placement of her in this country. Almost immediately, a number of difficulties occurred. They're set out in the evidence. It would be to trespass on the court's patience for me to go into them in any detail. But if I put it in this way, what happened was this, that the allegations were made.
Sorry, I'm just following this by reference to the chronology, which is
yes,
has helpfully been found. So you just said a moment ago that we know that it was the plan was for always to go to France, but that according to the chronology, it looks like that was a decision that was made after there were difficulties with the uncle.
Well, I don't know, my lady. The row, the principal row, arguably, between H and the uncle occurred, it would appear, over the trip to France. But, my lady, it probably doesn't matter very much. There was plainly a trip to France, and after which the uncle eventually said that H was ruining his life and bullying him, etc. From our point of view, the key is that the relationship such as it was between H and the uncle, broke down entirely, with cross allegations of a relatively serious nature made, but also allegations made by H about her care by the aunt in Tunisia.
By the
aunt.
And the
I'm sorry.
The grandmother.
Forgive me. The grandmother.
Yeah.
Yes.
I do apologise. There's no relevant aunt.
no.
No.
By the grandmother in Tunisia. The upshot of all of this was that there was a protection order, what ancients like me would call a police protection order, and there was an entry into foster care. But then, after a degree of investigation, there was an exit from foster care. So, arguably, those protective measures ceased. This may or may not be relevant, and I hadn't intended to go into a minute dissection of what was happening. But for one point, which I'll come to in the submissions, about the point of entry for public law proceedings, I might as well, my lady and my lords, mention it now. And it is this. It's common ground with my learned friends. That what we do know is that in public law proceedings, when at a final hearing, as opposed to an interim care hearing, the court is considering whether or not the threshold is crossed. That is, whether or not the local authority has made out one of the two limbs, one relating to present risk and the other relating to future risk. The matter is considered as at a particular date, and that date is when protective measures were made, so long as those protective measures continue. If they did not continue and there is a gap, then it is the date of the application. Now, that may only be of tangential interest, but, my lady, when looking at what the significance of whether or not there's habitual residence on a relevant date is, it is worth bearing in mind that public law proceedings, which are draconian in their nature because they entail the possibility of a serious interference with the rights of a child and natural parents by a public authority, have a fact-finding and determinative exercise, which does indeed, in certain circumstances, look back to the date of initiation of the proceedings. The precise date that we say is the date that should be looked at in public law proceedings when evaluating whether there is an habitual residence-based jurisdiction.
You mean as opposed to the date that would be relevant for the threshold?
They are coincident on our case.
No, I don't think so. Are they? Your application for a care order was the 18th of August. And I see your point. You say 4th of July was the removal into foster care under police protection. You say that came to an end because she was returned, but 9 days later, on the 13th of July, she was placed in foster care on an emergency basis. So that would be the, I mean,
yeah.
if you are right,
Yes.
if you are right, and we have to ignore the 9 days between the 4th of July and the 13th of July, you certainly can't say that the appropriate date's the 18th of August because
It's
the
only-
protective measures were in place on the 13th of July.
It's not, my lady, a submission on which I hang my case.
I think that's very wise, if I may say
but,
so.
my lady, I'm presenting it to the court because it does indicate that, if I can put it in this way, in all public law cases, the test for whether or not the threshold has been proved will be either the date at which the proceedings started, or some earlier date at which protective measures of a continuous nature were instituted, but it won't be a later date than the date of institution of the proceedings. And so there is a relevant date as part of the fabric, although I think it's judge-made law, of public law proceedings. That's all I say about it. And I therefore come back, my lady, to the facts, and your ladyship will see why there is an interest in looking at the detail of what happened. But, my lady, our case remains that the 18th of August, the commencement date of the proceedings, should be the date at which habitual residence was evaluated. I suppose, although we are not going to advocate it, by some parity of reasoning, it might be the earlier relevant date if that applies. But I'm not going to go there.
I was only taking issue with your suggestion that the threshold only the protective measures only began on the 18th.
And your ladyship on the facts is absolutely right. And my lady, I don't extend the point beyond that which I've outlined.
So anyway, you say the 18th of August is the institution of proceedings, and that's the relevant date for determining habitual residence.
And so, my lady, the proceedings are commenced. It's apparent, and we put the references into our skeleton, that the view of the local authority, then and maintained for some time, particularly maintained when in September the question of jurisdiction was raised. All credit to the local authority and its council for identifying the issue. The local authority's view was that habitual residence was in Tunisia, and that one should look appropriately to her H's future upon that basis. Plainly, the local authority shifted its position, but it did that only well into 2022. It's common ground and appears to have been accepted by Mr Justice MacDonald in his first judgment, that if the 18th of August was the date, the likely finding would have been habitual residence in Tunisia, and accordingly the outcome, as he put it, might have been different. So it's not just subject to ground 2, a technical appeal of interest in other cases. It's important to this grandmother in this case. What happened then, my lady, is perhaps an object lesson in how not to do it, because instead of the issue of habitual residence, properly identified only a month after the institution proceedings, being grappled with by the court, there were almost endless adjournments for reasons which I'm sure appeared good to those involved at the time, and it's not our task in this appeal to seek to lay blame, that the delay was combined with an extreme delay in ensuring the involvement of the grandmother. The grandmother was obviously a carer for the child, indeed her primary carer on the history. And on the face of it, she should not only have been made a party, which it took the court to do of its own motion in December, so 3 or 4 months went by without her having a full involvement at all, but she needed to be able effectively to participate in the proceedings. In December, the court directed that the local authority facilitated finding a solicitor for her and serving her with the papers. And my lady, months passed and that wasn't completely fulfilled. It was in March that she received papers, and then unfortunately all in English, and so quite useless to her. And so her effective involvement only took place in May. That was a hearing before Her Honour Judge Hughes, King's Counsel, at the Central Family Court. By that stage, the Tunisian authorities had become involved, and my lady and my lords, the recital to Judge Hughes's order of the 17th of May, and the reference is B64, but I don't need to take the court to it. It records that a Tunisian judge actually attended the hearing alongside a consular representative, and they expressed the view that H was habitually resident in Tunisia and should be returned to Tunisia for the Tunisian courts to exercise jurisdiction. So the interest in this case extended to the other state, remarkably not only attendance by a consular representative but by a judge, with the clearest of assertions as to what that state's position was. And my lady, I don't know, although attempts have been made to facilitate this, or at least to inform of it, whether the Tunisian authorities or a Tunisian judge are watching this hearing, but they may well be, because there is an interest. And as the court will, I'm sure, have gleaned, there are proceedings in Tunisia, although those proceedings post-date the English proceedings, and therefore they are perhaps of limited interest, and I don't hang anything upon them. And so eventually the case made its way to Mr Justice MacDonald, who some 11 months after the arrival of H in this country set about determining the issue. My lady, that is broadly the factual history. Without going into detail, I could indicate to the court the slightly less than satisfactory position in terms of contact. I could also indicate to the court the various fluctuations which have certainly occurred in H's views about Tunisia and what she wants to do, which have veered from an apparent readiness to go back to an opposition, current position, it would appear, to going back. But again, they are not, I think, going particularly to help the court. I could also, but that I suspect comes later, to complete the court's understanding, give an indication of what is happening in the public law proceedings, which, by the direction of my Lord Justice Moylan, when granting leave, he made clear with a polite warning shot across the bows as to what the final outcome might be, no matter what the interest of the jurisdictional questions of grounds 1 and 2 was. Lord Justice Moylan indicated that the progression of the public law proceedings should not cease, and so I can, in due course, update the court as to that. But again, that's probably not a matter of obvious relevance when it comes to the determination of the issues. So, my lady, if that suffices in terms of the overview and the background, I wonder if it would be helpful if I was to turn to the grounds of appeal and the supplementary arguments which we make,
yes,
with reference to the skeletons of the authority. some stage, my lady, I'm going to have to re-log on because I've been speaking for sufficiently long that it's timed out. But
Well, would you like to do that now? Do you need to do it so you can get ready access?
I need to get a security message, my lady. But what I will do is I will keep going as I easily can without referring to documents until the security message comes through.
All right. Well, as soon as it comes through, take a moment to sort yourself
in
out.
order to do it. So, my lady, logically, I'm going to take ground one first.
Of course.
I'm going to look with the court at Perpetuatio Fori, because it looks very much as if Perpetuatio Fori was central to Mr Justice MacDonald's view, and it certainly dictated what I might call the mechanics of how he said changes of jurisdiction should be reflected in the admissibility of English public law proceedings. And, my lady, Perpetuatio Fori means, we say, exactly what I said it did in opening, and it's a limited concept. What it means is that, I wonder if my lady would now give me the moment I asked for. Thank you, lady. That in a Brussels 2A case, it means that if, as in this case, a child changes jurisdiction, then subject to the provisions of Article 8 of that convention, of that regulation, there will be an eligibility for jurisdiction in the state of habitual residence, but that pre-existing proceedings continue to be effective until they are resolved. There's a CJU case which deals with that. I know it as B and K, for I was in it. What it did was to disapprove the line run by the Kingdom of Spain in that case, that Perpetuatio Fori meant once seized, always seized, for the life of the child. Seizing stops at the date of the resolution of proceedings, and then proceedings can start in the other jurisdiction. Now, that is not the scheme of the 1996. And Article 5...
Mr. Senator, could I just stop you for a moment? Because just speaking for myself, I'd quite like to identify the issues which the appeal potentially raises, not in any particular order.
Yes.
One is, what is the jurisdiction for care proceedings?
Yes.
Second is, and they overlap obviously in some respects,
Indeed.
does the Hague Convention, I think your argument is, exclude any jurisdiction that the domestic law might otherwise provide? I think you called it residual jurisdiction.
I do.
So that's the second issue.
That's expressed in very broad terms. We necessarily are more subtle than that.
I understand. I'm doing it in
headlines.
In headlines.
Absolutely.
The third is the date, and this again, for determining jurisdiction, not confined to habitual residence, but whatever the basis of jurisdiction is, the date for determining jurisdiction, and, although it may not arise in this case, what happens if there is a change during the course of proceedings which might lead to another ground of jurisdiction being established. And I think the fifth point is the point in the respondent's notice: does the Hague Convention only apply when the case potentially involves two contracting states? Now, is there another issue, or are those broadly the issues that we will need to consider?
I think that's probably enough issues, my lord.
Right.
I can't think of more. I suppose what I might mention, and it appears in Miss Renton's skeleton as an allusion beginning with A, not I, whether in fact these arguments are confined to public law cases, or whether they may have an effect in private law cases also.
Yes, I think
We're not concerned
no.
with that.
I think speaking for myself, better we confine ourselves to public law, because private law might raise different issues.
But it's something.
In particular, because the Family Law Act applies directly to private law issues, but does not apply to public law issues. Say, for your point, but not in the Family Law Act about restrictions on the use of the inherent jurisdiction to place children in the care of a local authority.
Well, that's right, my lady, and Section 100 has appropriately been put in the bundle.
Yes.
But equally, my lady.
So what I'm just setting out those issues. So in going through, because you started with perpetuatio fori, which again might not seem necessarily the easiest entry point into the issues. But I'm not trying to take you off your course, but just can you, as you go through your submissions, keep an eye on those issues and tell us what your submissions are in respect of each of them.
I will, my lady. Perhaps through a failure of imagination, I was sticking to in effect, the order of the ground.
Yes.
Because I'm conscious that this is an appeal.
Yes.
Not a disposition on jurisdiction generally. But, my lady, I'll do whatever the court finds.
You're being very disciplined. Other people seem to ignore the grounds and go wherever they like. So thank you for
I'll
that.
easily do that, my lord. But if I put it in this way, I mean, perhaps I ought to be conventional and tie these submissions more closely into our skeleton. Because if I did, my lady shakes her
well,
head.
we've read your skeleton,
Exactly.
and no doubt if there's particular parts of the skeleton during the course of your submissions, you'll say that's expanded on in paragraphs, whatever to whatever.
Just so, and I have it in front of me.
Yes.
But I will, if I may, continue on perpetuatio fori, because in the way that Mr Justice MacDonald conducted the exercise on what is now ground 1, that appears to have been, when combined with Article 5 of the 1996 and the observations principally in 2 paragraphs of the Lagarde report, that seems to have been the conclusion that he reached, that perpetuatio fori is not featured in the 1996 Hague Convention, and that indeed the provisions of Article 5, which we reproduce in our skeleton, paragraph 19, it says, and this is Article 5.2, subject to Article 7, and the court perhaps need not be concerned directly with Article 7. In a case of a change of the child's habitual residence to another contracting state, the authorities of the state of the new habitual residence have jurisdiction, which is baldly put and without a saving provision as to current proceedings. Of course, the reference to another contracting state feeds into the respondent's notice, but I'm not going to deal with that now. So, taking it that there is no positive provision for perpetuatio fori in the 1996, the practice guide indicates, with practical examples, that there can be, in effect, a cessation of jurisdiction taking practical effect when habitual residence in the country in which the proceedings are taking place is lost. It's going to be, to avoid the saving provision for abduction cases, it's usually going to be a lawful or consensual change of habitual residence. There's an argument that in this case, this was the lowest, a highly controversial change, and one in which the grandmother had no input and certainly didn't consent to. But I'm not sure it's going to profit me or the court if I delve into that. Let me stick to the basic principles. We say, and without going, my lady and my lords, into the detail of the judgment or into what we place in our skeleton, we would say this. There is a distinction between the permissive effect provided for in Article 5 for changes of habitual residence to be reflected in changes of jurisdiction, on the one hand, to the domestic rules, including the domestic rules as influenced by the 1996, on the integrity of English proceedings, including English public law proceedings. The two things are not coterminous. The one does not necessarily change the other. We say more than that. In this case and this example, it positively should not change the other. The line which, if I can use that I don't mean to disparage either, the principal position which my learned friends for the local authority and the guardian offer goes rather like this, subject to the respondent's notice, of course. Welfare and child protection are at the heart of the 1996 Convention. Therefore, if it is to be interpreted and applied purposively, then there must be a welfare-based approach in its application. I may have put it more succinctly and effectively than they did, I don't know. But that's a powerful argument, I recognise. I pause to remind myself that welfare is also at the root of the Brussels 2A regulation. But that may not get me very far, because that contains specific provisions about habitual residence and relevant dates. But my lady and my lords, we say, and we're heartened to see that the intervener takes the same line, that quite irrespective of the problems of practicality which Mr Justice MacDonald's approach throws up, of course I'll come to, but if one goes into those and relies upon them too much and too deeply, they tend to result in a policy-led rather than a law-led approach. Maybe the same thing. That as a matter of principle, there needs to be an integrity and a predictability in proceedings and in whether or not they have a proper basis, and in being able to know what that basis is. If I look at this case, and my learned friends will of course correct me if I have this wrong, I don't think that alternative routes to jurisdiction, to an habitual residence-based jurisdiction, were built into the contemplation of the court in the making of the orders which it made between August, when the proceedings started, and July, when Mr Justice MacDonald concluded. What the court could have done and what the court should have done, we say, is to have determined that there wasn't an habitual residence promptly. I think the practice guide suggests it's done by day 18 or something like that. But
when you say the practice guide, do you mean PD? Practice direction?
Yeah, yes.
You don't mean the Hague Conference practice guide, you mean practice direction?
I don't. Domestic, my lord. But, my lord, what the court could have done, and plainly should have done, with great respect, is to say that urgent protective measures were made pursuant to Article 11. Good practice in public law, and for that matter private law cases, is very well established, and when Brussels 2A applied, they were made under the like provisions of Article 20, and the court made clear either that it had not yet made its mind up about jurisdiction, or that it had, and there wasn't a root public law jurisdiction, but the court was exercising that emergency jurisdiction pursuant to Article 11. The court could have done that, and should have done that, equally, and it will come back to another submission that we are going to make, the availability of Article 11, like the availability when Brussels 2A was current of Article 20, provides a jurisdictional recourse of necessity for emergencies, which is uncontroversial. I say a jurisdictional recourse because what has always tended to happen under Article 20, for example, is that courts have made interim care orders, thus making them in a provision of the relevant part of the Children Act 1989, but doing it also under Article 20. But if one looks at whether it is necessary or appropriate to look at some other form of residual jurisdiction where there is extant a route under Article 11, well, that's a submission that we're going to make, bearing in mind that I'm juggling all the slightly interlinked points under the other heading in round 2. But, my lord, my lady and my lords, there was a jurisdiction, undoubtedly, to make orders between August and July. It's very important, we say, that the parties should be able to identify what that jurisdiction is and is not. If, under it, orders are made or contemplated which may radically interfere with the exercise of PR by the parent or person in the position of a parent and the position, the Article 8 rights of the child. If one follows what I might term the MacDonald line, then there is a vacancy in terms of adjudications by the court, as to, in this case, in no man's land of no less than 11 months, in which lots of things were done, in which proceedings were maintained, but in which the jurisdictional basis of those proceedings is simply not established one way or the other. That in principle, where, and I will be wearying the court by repeating it a third time, particularly where very serious interference is contemplated, that is not a tolerable position in principle for the persons whose rights are potentially affected. Not only that, but in a case of this kind, it may cause the court to be tempted to take its eye off the ball. If this court had made a timely determination, and that determination would have been habitual residences in Tunisia, then the course of the case would have been different.
Don't focus only on habitual residence, because the issue is jurisdiction.
Yes, no, I agree.
The jurisdiction might be Article 11,
Yes.
might be habitual residence, might be presence.
Yes.
And your submission simply is that when the court is being asked to exercise its jurisdiction by making orders, it's got to make at least a preliminary determination as to what that jurisdiction is. Can't just ignore the issue. So that's why the pro forma orders saying it appears to the court that it has jurisdiction based on habitual residence, or it appears to the court that it has jurisdiction based on Article 11. That was the case in the Spanish case with Mr Justice Leaven. So you're saying the court shouldn't simply go ahead, make orders without considering the basis of the jurisdiction on which it's making those orders.
That's a starting point.
Yes.
For my submission.
I would have thought it was rather uncontroversial
And
that the court should
I
decide its
I try to be
jurisdiction
uncontroversial
before.
until I become controversial.
Yes.
And I'm gradually going to become more controversial.
Yes.
So that's the starting point.
Yes.
And simply not done. And plainly linked to that starting point is that whilst a holding position is all very well, it's quite intolerable for a holding position to be maintained over, for example, 11 months.
If you need a substantive determination, it needs to be expeditiously determined. And that's why you pointed the PD that suggests 18 days.
Right.
How that would be accommodated with the current state of the court list, I don't know. But that's the intention behind it. You can't just allow the case to drift without a proper determination of the issue of jurisdiction.
Our observation, my lady and the lords, which very much follows from what my lord has just said, is that in the real world, although judges with great respect at various levels have been saying for many, many years, habitual residence, to pick that issue, is a straightforward factual matter. It can be determined without oral evidence usually. It can be determined without having very elaborate hearings. The practical...
In the vast majority of cases, yes.
Of course.
Yeah.
But in cases which are complex, of which there are significant numbers, and particularly in cases where there is perhaps a slightly tangled picture factually as to what has happened and why. In the real world, again with listing considerations, and perhaps with judges who think, ooh, that's rather interesting, I better give some directions for the filing of some evidence, and it goes on from there. Whilst 11 months in the grand scheme of things is really an exceptionally long time,
Yes.
these things may not, sadly, reliably get resolved within the desired 18 days, just as not all 1980 Hague Convention cases get resolved within 6 weeks, and not all Section 31 cases get resolved within 26 weeks. It's a fact of life. And if one bears that in mind, then the impact of proceeding without a proper determination of jurisdiction, it grows, And what we say is the detriment caused by Mr Justice MacDonald's approach grows exponentially with the delay. But my lord, with respect, is quite right. The starting point is that there's got to be, and it's there as good practice anyway, some determination of jurisdiction. And it would be quite easy for a judge to say, well, there is an issue as to habitual residence in this case. I haven't been able to decide it. I'm taking measures to ensure that I can decide it very rapidly. But in the interim, I'm satisfied that the relief that I'm being asked to give is relief that is covered by Article 11. And therefore, I can make, for example, an interim care order. But let me proceed from that. We say that Mr Justice MacDonald was right to look at habitual residence as an arbiter of jurisdiction. How does that happen? Well, it's because unless Mr Toomey and Mr Lamb succeed, he was right in saying that at first blush the 1996 applies, and that therefore the arbiter of a broad brush arbiter of a 1996 jurisdiction is habitual residence. So the first question, before looking at what the alternatives may or may not be, is to look at whether or not there's habitual residence. So hopefully, uncontroversially, Part J, the respondent's notice, I can say the court needs to look, bearing in mind that we are a signatory to the 1996 to habitual residence. Although we will always have an Article 11 jurisdiction which happily mirrors, we say, any residual, if I'm pardoned for using that word, emergency jurisdiction based on physical presence anyway. So there must be a purpose in asking that question. If habitual residence is in another jurisdiction, well, without my lady and my lords wishing to trespass on the respondent's notice, Articles 11 and 12, particularly Article 11, do not just contemplate that the other state, that is the state of habitual residence, will be a convention state. And that bears a degree of thought, because arguably Article 11 provides, even in the case of emergency relief, a degree of comity and interaction with a non-convention state, where the convention state is the state of non-habitual residence, physical presence, and the non-convention state has habitual residence, and the reference is to the end point for the currency of the protective measures. So there is that degree of interlinking. What my lady and my lords, the court, we say, has to consider when determining habitual residence is habitual residence as a qualifying criterion for jurisdiction. And logically, for the reasons which I've given, that must only relate to the relevant date, the date of the inception of the proceedings. Section 7 of the Family Law Act, and I know the court will forgive me for jumping about for the sake of speed, but my lords and my lady of read it and are certainly two of the court are very familiar with these provisions. Section 7 demonstrably predates both Brussels 2A and the 1996. Its introduction came with the Children Act 1989. The Family Law Act, as Mr Justice MacDonald, in an uncharacteristic fulmination in his first judgment, indicated, is not perhaps the most user-friendly of statutes, and over the years it has only got worse, as most people do. But what we've done, perhaps to compound the unhelpfulness, is in the authorities bundle we've provided a version which shows lots and lots and lots of amended provisions and lots of footnotes. Again, I don't need to take the court to it unless the court wants me to, but what it does show is a degree of history, and if one engages in the archaeology of the Family Law Act, one comes up with the following. First of all, query, it was never intended to be principally an arbiter of jurisdiction with regard to matters other than those internal to the United Kingdom. That was the principal intendment, but it grew, and as the jurisdiction developed, it started to become and to be taken as, indeed it inevitably was from the beginning, in many respects the arbiter of how jurisdictions to make particular orders were based, and there are provisions for what are private law orders, and there are provisions 11D for inherent jurisdiction cases, and that's where my reference to emergency provision comes from. But what is quite plain is that Section 7 was a subsequent amendment, but one which substantially predated Brussels 2A and 1996. What it originally post-dated was the 1961 Hague Convention, which I rather think started the ball rolling on habitual residence. But
Yes.
our attempts in the time we've had to research Hansard to see what the basis for the introduction of Section 7 was haven't so far met with any success at all.
Can I just take you back for a moment? You said habitual residence is a qualifying criteria, and it can only relate to the date of commencement of the proceedings. Only, I'm focusing on the word only, because Article 5.2. So you might have a case not habitually resident at the commencement, habitually resident at the date of the final hearing, habitually resident at the date of commencement, and habitually resident at the date of the final hearing.
I agree.
Okay.
Can I come to those and dissect?
Okay.
And I'll dissect the possibilities. Hopefully demonstrate that there is another way which is more respectful of the need to assert with clarity what a jurisdiction is and is not ab initio, but which at the same time caters for the fluidity of habitual residence as provided for in Article 5. And I will come to the examples that Your Lordship gave. But
you're returning to your submission that, as I think I understood it, that Article 10, when you say mirrors jurisdiction based on presence, Article 11, sorry.
10.
Article 11 mirrors jurisdiction based on presence.
It provides an emergency jurisdiction,
Yes.
which is similar
Yes.
to a jurisdiction of necessity for
Based-
emergencies
yes.
based on presence.
Right.
But of course, what Article 11 doesn't do is to provide the jurisdiction that Mr Justice MacDonald obiter judgment said he could have recourse to, or that the local authority seeks to rely upon.
Well, so you might have,
to determine
yes,
proceedings.
so Article 11, you say is a short-term emergency.
Yes.
So are you saying there isn't jurisdiction based on presence, or somehow that excludes jurisdiction based on presence, or what? Are you coming to that later?
Why don't I deal with it now? There is a lot of material, and in part I rely upon it, which says that the 1996 does not dictate domestic provision in detail. So it isn't going to eliminate particular domestic provision, but that if domestic provision is inconsistent with the 1996, particularly if that domestic provision is not a creature of statute, and if we do have a residual jurisdiction here, it most certainly is not a creation of any English statute, it is judge law, then it should give way.
Right.
Article 11,
Yes.
thankfully, resolves that problem, because if it is said that there is an emergency physical presence-based jurisdiction in this country to make orders, including public law orders, in respect of children, and that there always has been the ability to make emergency orders in respect of children. It's a jurisdiction of necessity. Article 11 seems to provide a complete coverage. There isn't actually, beyond the mechanics of what's done in the other state, a limit of time to the operation of Article 11. But by common consent, I hope, Article 11 measures will not include the resolution of substantive public law,
Okay.
or for that matter, private law proceedings.
So it doesn't cover then residual jurisdiction, as I adopt your phrase, based on presence to make substantive orders. So how, if that is your submission, how can, if that jurisdiction exists, be said to be inconsistent with Article 11? Because you say it doesn't give the court jurisdiction in those circumstances to make such orders.
It's inconsistent with the principle that habitual residence is the determinant of jurisdiction. I'm dealing with the position if habitual residence has not switched.
So your position is that the convention covers the ground. You cannot institute proceedings with jurisdiction in this country except in accordance with the convention, either Article 5 or the protective measures.
Couldn't or shouldn't. And I think I'd be saying both, because it may be that there is a discretionary access and the court would have to apply a self-denying ordinance to say this far we can go, but no further, because the child is not habitually resident here. We can use the emergency jurisdiction. It happens to coexist happily, although it's the 1996 jurisdiction doesn't contain, as does the Children Act 1989, a specific provision allowing for an interim care order to be made. But it must be, we concede, that an interim care order can be made under the aegis of Article 11, because by the route of Article 11, that can be accessed. But it is either wrong at the highest, or bad practice at the lowest, to have recourse to a residual jurisdiction if the 1996 applies, and if to do so would be to trespass on the jurisdiction of habitual residence in the other state. can I come back to perpetuatio fori and the exercise?
Well, when you say to trespass on habitual residence in another state, the Article 5 is very clear. It only applies to a child who is habitually resident in a contracting state. So why are you introducing habitual residence in another state? That's not included within the convention at all.
The approach of Mr Justice MacDonald, unless he's wrong, and perhaps I don't want to get too tangled in that point, is to give respect to habitual residence in the other country. Why did he ask the question, is there habitual residence here or habitual residence in the other country? I suppose what I could do to slightly sidestep your lordship's understandable and correct confrontation is to say...
It wasn't a confrontation.
Well,
it was a question.
I've had
As confrontations go,
as confrontations go.
It's perception. It's your perception which is
great.
important. So sorry.
Let me just answer the point.
Yeah, no, sorry.
That really it's to do. It's not just that there's habitual residence in a non-contracting state. Is that there isn't habitual residence in this state.
I understand. It was you used the word trespass.
Yes.
That was what I was focusing on.
Well, I have a vestige of a basis for saying that.
Right.
And that is this. Whilst the principal submission would be that we are a 96 state, 96 says that habitual residence is the principal basis of jurisdiction, you can ask the question, is there habitual residence here? Which is the question that Mr Justice MacDonald rightly asked. But if there's habitual residence, if there's no habitual residence here, but there is habitual residence in another non-contracting state, then parts of the 1996, like Article 11, do make reference to the situation where there's habitual residence in non-convention states, and broad principles of comity and welfare do tend to suggest that where there is habitual residence in another state, even if it is a non-convention or non-regulation state, weight must be given to that fact. Not perhaps determinative weight in terms of the outcome. There was a strand of thinking which your lordship, my Lord Justice Moylan, will be utterly familiar with, about a worldwide approach to comity, which has resulted in many interesting cases.
Yes, but that issue would be relevant, for example, to an application for a summary return order, which after all is a welfare-based order. Or alternatively, an application for a stay of the proceedings here on the basis that there were or should be proceedings, which would be difficult to see that sort of taking place without also an order for a summary return. So that's why, I mean, you can't just say comity, as a principle. In what context?
Yes,
and it doesn't. I don't see how comity has an impact on whether or not this court has jurisdiction. Might have an impact on stay. Might have an impact on, I suppose, on a welfare return a bit. But I just don't see how it applies to what your submission, your current submission.
because that's only the first stage.
Right.
One moves from a broad consideration of comity to the more modern consideration of proximity. And that is undoubtedly a consideration that is current, and we say flows from the Hague Convention. The principle of proximity, also familiar in B2A, that it is better for the jurisdiction of habitual residence to determine matters because broadly of considerations of proximity. That's a material consideration.
But
Is
it's
there-
picking up what my Lord Justice Newey was saying, that your submission effectively is the Hague Convention excludes residual jurisdiction or jurisdiction based on presence, if I've understood your submission
Not
correctly.
entirely,
Not entirely.
because, for example, an emergency jurisdiction is plainly not excluded.
Okay.
So it is covered by Article 11.
Yeah, but residual. I mean, say an independent or another source of jurisdiction based on presence.
It exists, if it exists, but having recourse to it is either wrong or bad practice. I think I was quite careful to give a high and a low point in my in my answer to my lord.
And in your follow-up, you said that you have to give weight to the fact that somebody is habitually resident elsewhere. That doesn't sound like a jurisdictional point. That sounds like something that might bear on whether or not the court chooses to exercise jurisdiction.
Well, question one is there such a thing as a residual jurisdiction? Question two is, what is it? Question three is, in what circumstances may it be accessed, and in what circumstances may it not be accessed? And we would say that in answer to question three, if it conflicts with the guiding principle of B2, of the 1996, then it should not be accessed.
And your answer to questions 1 and 2?
Can I come to that?
Certainly, Mr. Central.
Sorry, but that's almost saying that the convention applies even though this in the same way, regardless of whether the other relevant state is a contracting state or not a contracting state.
That's because the convention applies to us. It's the arbiter of our approach to our domestic jurisdiction. That may be wrong, and that is in effect part of the case in the respondent's notice, that Mr Justice MacDonald was quite wrong in thinking that he was bound by the fact that we are a member state of the 1996 to carry out his habitual residence inquiry in the way that he did. But I'm sticking at the moment, if I may, to the propositions that he made.
Yeah, I don't understand that, but if the child was habitually resident in a contracting state, the situation would be very different from a child being habitually resident in a non-contracting state. And I was just pointing to what the effect of your submission appeared to be, that the application of the convention is the same in both cases. Not whether it applies, but the application of it.
Its effect as being binding on us, that's the point that perhaps my lord distinguishes, is absolute because we're a signatory.
Yes,
state.
but sorry.
It may indeed be, my lord, that there is a difference in terms of some aspects of the approach if the other state is a non-convention state, but not a difference, with great respect, which affects the discernment of jurisdiction, because that is domestic. It's a question of whether there's habitual residence here or is not. If there is habitual residence, no habitual residence here, but there is habitual residence in a non-convention state, query, does that mean a different route to the determination of jurisdiction? That's not a road that Mr Justice MacDonald embarked upon. and perhaps I shouldn't either. Certainly
Well,
not.
except the child's present and has been present here throughout.
Yes, indeed.
So that jurisdiction exists.
If there is a physical presence jurisdiction to make what I might call long-term resolution of welfare cases and to decide in whose care the child is placed,
Yes.
to echo the language of 1(1)(d) of the Family Law Act. It all depends on the answers which the court
Well,
gives.
quite, because it'd be rather, I mean, I appreciate the context of the appeal, but it'd be rather futile if there was substantive jurisdiction based on presence to say, if that issue had been addressed right at the outset, the court would have decided it did have substantive jurisdiction based on presence. That was not the approach the court adopted, so it needs to go back for a rehearing. For what purpose? So I think we have to grapple with it.
Can I grapple with it when I've grappled with the mechanics of ground one and when I've answered your lordship's other questions, which I have very much in mind about what the alternatives are. And I might even postpone my response to your lordship's most recent point until after I and the court have heard my learned friend on the respondent's notice, because I think there's a logic to that too. If, my lord, I look with the court at the mechanics of making a determination of jurisdiction referable to the date of the inception of proceedings, and on the basis that the first question to be asked is there habitual residence here? If that question is asked and answered in the negative, as it would have been in this case, at a very early stage, let's say counsel of perfection, the proceedings started on the 18th of August, and at the hearing in September, the court has said, right, this is urgent. It's plain as a pikestaff, isn't it, that habitual residence is not here but in Tunisia. The local authority would have said yes. And whether or not the grandmother had an input, the court could have said, well, there it is, London Borough of Hackney. There's no habitual residence here. Habitual residence is in Tunisia. Where do we go from there? It's quite likely that protective orders, possibly exactly the same protective orders, would have been made, but there would have been a greater focus on looking, perhaps, or more than perhaps, conventionally, on provisions for a return of H to Tunisia. It wouldn't follow as night followed day that she went to Tunisia, but that's what the court would be focusing on, rather than making directions for a long-term hearing. And the court would also say, and we make these provisions, including an interim care order, pursuant to Article 11, because that gives the court an emergency jurisdiction. Or the court could say, without prejudice to anything else that I might be saying, and we are making these in the available inherent or residual jurisdiction to deal with emergency situations involving children in this country, but we're doing that under the umbrella, the enabling umbrella of Article 11, and therefore we have recourse to the domestic provisions in the Children Act. Then it would be clear. Let's suppose, my lady and my lords, that most regrettably, and notwithstanding the keenness of the grandmother and the Tunisian authorities to see a return to Tunisia, nothing much happens along those lines, and that quite irrespective of other events in the life of H, she lingers in this country in foster care, albeit francophone foster care, on and on and on. And eventually it looks as if there's a case for saying that she has acquired an habitual residence. What should happen? Well, on our scenario, what might properly happen is this: that the care proceedings, the public law proceedings, which don't really exist, they've been disallowed on the basis that the case proceeds under Article 11 or an emergency jurisdiction. They don't exist. But there is then nothing to stop the local authority saying, right, we now assert that H is habitually resident in this country, so we are again issuing proceedings under Section 31 of the Children Act. This time, there is habitual residence. We invite the court to so rule. And therefore, there are then proceedings which start from the beginning on an impeccable basis.
So just so I'm clear, I don't think I'd quite picked it up. I sort of thought that when you were talking about the making of an Article 11 order at the beginning, that the emergency, that the care proceedings would still be there bubbling away in the background. But from what you've just submitted now, it seems that you're suggesting that whenever a court makes an Article 11 emergency proceeding, any care proceedings should be dismissed.
That's one submission. That's my starting
That's your
point.
submission.
That's a starting point submission. I'm dealing in answer to my Lord Justice Moylan's request to look at alternatives. That's one. That would.
But is that what you say should happen? Is that your case?
In that, the root proceedings, the application for a care order under Section 31, wouldn't have a jurisdictional basis if habitual residence is the arbiter. Yes, discharge the proceedings and proceed under Article 11 or under such other residual jurisdiction as there may be. And I can see it might be argued that that's under the Children Act.
Well, the residual jurisdiction might be Section 31 Children Act presence.
Yes. So my lady, that's only the starting point submission.
All right.
The second submission, more perhaps conservative, would be that following the initial determination that there wasn't an habitual residence-based jurisdiction and the taking up of an emergency jurisdiction under Article 11, mirrored by, perhaps, to use that word, or covered also by domestic provision, the court would make it clear that the local authority would not be and could not be proceeding on other than an emergency basis. But then, when it became apparent, and the local authority's assertion that habitual residence was here, it could come back to the court and say, there is now habitual residence. Therefore, the restriction in the exercise of the jurisdiction which the court imposed, having made a finding that there was not habitual residence, is now lifted, and the court instead has a full jurisdiction to determine whether or not it should make a final care order or other final relief.
Help me with this, though. I suspect you're going to say patience. I'll get there.
No, my lady.
So we have the Article 11 emergency. Time comes when an interim care order is made, which does seem to suggest that we have to keep the Children Act proceedings underway if you're going to have a legitimate interim care order. The emergency period, you would say, comes to an end because the very nature of Article 11 is an emergency. But we haven't got to the stage you've just told us about where habitual residence has transferred by a fraction of time to this country. So in the period when the Article 11, you say, emergencies run out, but the child is still has not acquired a habitual residence in this country, what happens? Have we got a complete gap, or do we then say, thank goodness we've got our residual jurisdiction based on presence for the Children Act care proceedings, and those will carry on once the immediate emergency is over and Article 11 served its purpose?
Yes, my lady. It had not been in the illustration, my second illustration, it had not been my suggestion that when the local authority asserted that there was now habitual residence, the emergency provisions had ceased. And in this case, it might well be argued they didn't cease. That possibly is because H was not returned to Tunisia, but the need for her to be accommodated in foster care.
But I'm a bit confused, because I think you said earlier in your submissions that, of course, they could make those emergency orders and so on, but what they couldn't do was sort of take steps that would be determinative. So really, you're saying in that interim period between the making of the Article 11 and habitual residence transferring to the UK, the child would effectively be frozen in aspic, because although she would be legitimately subject to an interim care order living with foster carers, no future planning could be conducted, because that would be determinative, which you say is prohibited. But correct me if I've misunderstood your argument.
That is likely to be what the court would consider it should not do. Experience shows, and there's ample experience of the position in care proceedings to which B2A applied. And there I would agree with the implied suggestion from my lady that in some cases at least tentative future planning was undertaken, going hand in hand with an acknowledgement that there was another jurisdiction to which it might be that the child should be returned, and that relief, because there was no habitual residence, was on a necessity basis. My lady, I entirely understand the point that your ladyship makes, but there are two possibilities. The first is that, as I've indicated, the need for the emergency measures continues, and as I made clear, there isn't necessarily a time limit to how long emergency measures need last. And so perhaps they last for months, and perhaps with those emergency measures still in place, utilising powers under the Children Act, habitual residence is acquired, and then the local authority applies and says it's now more than legitimately an emergency measures case. The court can look at what a final welfare-based provision should be, not emergency relief, but a determination. The other possibility, which is that which my lady puts to me, the more difficult one, is suppose that the emergency, it's rather like, perhaps, my lady, what happened in the early days of H's presence in this jurisdiction. Suppose that there are some protective measures, and suppose that those include an interim care order. And an interim care order has an end date, although there are provisions for renewal.
Automatic now.
That's right, my lady, with respect. And those provisions mean that, in a sense, it is open-ended, though it is amenable to review. But let us suppose, my lady, that an interim care order is made, and after a month or so, the local authority takes the view that there is no longer any need for the interim care order. The local authority having an onus upon it to review its own interim care orders to see if they need to be sustained. And the local authority said to the court and to the other parties, well, there is no longer a need for these measures. If there wasn't habitual residence, then why should there be proceedings.
Well, if there's no longer any need for an interim care order, it would be highly likely that the local authority would be making an application to the court for permission to withdraw the proceedings.
But in any event, it would be likely that the court, if it had decided that the proceedings were emergency only, would say, very well, no need for an interim care order, that's discharged, and there is, as my lady put it, nothing left. But that might be entirely proper and consistent with good practice if the local authority was not able.
We're getting into deep waters there, Mr Setright, because then, you know, in the case of this type of a case where we've got a child from a non-contracting state who's present in this country, there's no one exercising parental responsibility in this country, the child is in foster care, you can't just, there's no one therefore to sign a Section 20 accommodation agreement, therefore...
Yeah. My lady, those are questions which come back to the basic question. What, is there a residual jurisdiction? What is it? What does it
Which is
cover?
why I keep saying, do you accept there's a residual jurisdiction based on presence, which allows local authorities to conduct care proceedings based on presence?
If there was or is such a jurisdiction, then subject to a consideration of its discretionary exercise, then it could potentially apply. But that, of course, was not a determination which any court made until it was considered by Mr Justice MacDonald in the July hearing. And even then, he didn't make it, he didn't have to, because he didn't reach it. But yes, of course, my lady, with respect, if the answers to the earlier questions, what is the residual jurisdiction, does it exist, in what circumstances can it be exercised, is there a discretionary exercise of it, can it go beyond emergency provision? If the answers to those are, as it were, against the points that I seek to test with the court, so as not to be too bold, then it could be exercised. And that would be a point that the court would be considering. I'm cautious.
I'm conscious of taking you out of turn, for which I do apologise,
yeah.
but this absolutely goes to the heart of your ground too, though, doesn't it? And which is why I'm...
Oh, yes.
You know, really, you say the court erred in its determination that the court can assert a residual common law jurisdiction based on physical presence in the event that the court is satisfied it doesn't have it on basis of habitual residence. And I'm asking you whether effectively you maintain that part of your appeal, or do you accept that with all the caveats and everything you've told us, that the reality is that there is such a jurisdiction, and the judge was right in concluding that it was. Whether you say he should have used it in the way he did, but I'm just trying to pin down these difficult jurisdictional issues.
My lady, I'm not going to put it in this way. I'm not going to concede the existence.
Right.
Because what we seek to do as part of round 2, in circumstances where the nature of the jurisdiction, particularly post the ending of B2A, is likely to be a judge-made jurisdiction. And down the years, it's been argued either way, from a high point with Lord Justice Mumby in saying, well, no, there isn't a non-habitual residence-based public law jurisdiction, down to the original Mr Justice Singer, of course there is, there must be, and so there is a jurisdiction which is a residual jurisdiction. We would invite the court, for the benefit of practitioners and judges, to define it. We recognise that there may be. I don't know whether that helps.
Can I just pick up another point? You say, and you explained why these proceedings should not have taken the course that they took. But they did. Does it follow from what you've said so far that Hackney could today bring new proceedings?
If, as appears to be the case, H is habitually resident in this jurisdiction, then the operation of the perpetuatio fori principle means that it could say, we have habitual residence, we can start Section 131 proceedings based on habitual residence. That is precisely the point, my lord, that I've been addressing when looking at how it would work if there had been a change.
I mean, just two things from that. First of all, you've explained, well, you've touched on the fact that it can be very inconvenient. You can end up with delay if all these matters are deferred. This would be a recipe for more delay. You get to the point where the child has acquired habitual residence, then new proceedings are brought with more delay.
So why can't, given your non-concession, why can't the court just continue on with the public law on the basis of presence, now upholstered, if I might put it like that, by habitual residence?
If addressing my lord's question, if my lady is right, and notwithstanding the lack of habitual residence, and anything that may follow from that, because that provides a coloration to the approach, which may, for example, predicate that the principal endeavours are looking to a return to Tunisia. But subject to that point of coloration, and without making the root concession, if my lady is right, then, putting it this way, the public law proceedings then get beefed up by the introduction of habitual residence. Even then, it does feed in to our case on ground one, which is it is much better to do it that way. It's principle, particularly in public law proceedings. And even if one starts, I'm sorry, I know my lord was going to speak, but if I may, I'll complete the thought and the answer. Even if my lady is not right, and fresh proceedings have to be started, it is not at all necessarily the case that they would start from complete scratch, because one would expect that the teams on both sides who'd been involved in the essentially public law in character emergency measures would remain in place. There would be a guardian, almost certainly, in place. And so it wouldn't be the case that lots and lots of time-consuming new directions might have to be made. But, my lord, I quite take the point. Starting fresh proceedings, or, in any event, surgery to provide an implant into extant proceedings may have procedural consequences. But we say nothing like the potential difficulty of doing it Mr Justice MacDonald's way, which, if I may, I will come to in comparison, if what I've done is to set forth the ways that our line on ground one could work in satisfaction in terms of our case, of my Lord Justice Moylan's question. Though to complete the answer, I'll have to look at what we say happens on Mr Justice MacDonald's approach and why we say that that is not appropriate.
Can I just pick you up on something a submission you made in respect of Article 11? Article 11 gives a state jurisdiction or a court's jurisdiction. It doesn't dictate, because the conventions don't interfere with domestic law. It doesn't dictate the form. So picking up the point my lady made, they have to be proceedings under the Children Act. They're not proceedings under the convention, they're proceedings under the Children Act. So they are an application for a care order if they're brought by local authority, because the local authority has no other route to make an application. I just don't understand your submission. Sorry to put it rather bluntly like that. I think I'm being confrontational again. I don't understand your submission that the court dismisses the Children Act proceedings, because then there aren't any domestic proceedings.
There's an analogy which I know my lord is familiar with Section 5 of the Child Abduction Act, which provides a route to provisions of the domestic law for interim relief in the pendency of a 1980 Hague Convention case. It's commonly used for a number of purposes, one which down the years has been, to say the least, slightly controversial, is where the court directs that a child is accommodated by a local authority.
Yeah, well, let's not go down that route, because that's a completely... What you're saying is this is a freestanding provision that gives the court to make any order, any emergency order of any sort whatsoever. That's what I'm testing. I don't think it's not vesting the court with powers. It's not vesting domestic authorities with powers that they don't have under the domestic jurisdiction.
That argument, and I hope your lordship will forgive me, that argument was run to exhaustion under the 1980 convention, and that convention doesn't give particular powers. They're both Hague conventions, and the 96 grew in some respects out of the 80, as my lord well knows. But what both do is to allow a court to access extant provisions within the domestic jurisdiction. Your lordship is, with respect, quite right that the 1996 doesn't dictate or censor the jurisdiction, the domestic jurisdiction. I made that concession earlier in these oral submissions. What it does do is to allow aspects of that jurisdiction, powers in that jurisdiction.
I understand it was your submission that the care proceeding should be dismissed. That was all I was questioning. I thought that was a submission that you
That's
made.
the bolder of the two submissions.
What?
That's the bolder of the two
Bolder?
submissions.
Well, I think you just accepted the... Oh, well, okay.
Not quite, my lord. That's the bolder of the two submissions.
Right, okay.
Because, and if my lord wishes me to pursue it, and I will, it's because the relief which is sought is necessarily relief of an interlocutory and temporary nature. One of the principles of the Children Act, and that applies to public and private law proceedings, which marked a change, as us oldsters can remember, from the wardship-based jurisdiction in which public law cases, when they got to the High Court, were determined, was that it was a finite jurisdiction. Upon an issue being determined, that was, unless there were other issues outstanding, to be the end of the process, in contradistinction to wardship. So if there is a restriction, then once such orders that needed to be made have been made, and if they are time limited, if they reach the end of their time, then strongly arguably there are no admissible proceedings. But I quite take the point that it may be bold to say the proceedings should be dismissed on a contrary finding. It may be that my second stage position, which is that articulated to me by my lady, is right, and that it is then a difference of coloration, a very significant difference of coloration, which results from the finding that there isn't habitual residence, but also realistically a self-denying ordinance on what is done under the extant public law proceedings, if the principal objective is to investigate and, if possible, to return, quite possibly without reaching a final hearing in the Section 31 proceedings, if that is the effect of a finding of non-habitual residence. But, my lords, I'm diverting myself, with some assistance, from looking at the mechanics, and what I was going to go on to was the mechanics of Mr Justice MacDonald's formulation is that which is followed. If I've done my best, however inadequate, to deal, my lord, with my Lord Justice Moylan's points on the shutdown, if I can put it in that way.
Just before you move on, I'm
Yes.
probably saying that I haven't grasped something. On this hypothesis, there would in some sense have been jurisdiction in the court at the stage the matter was before Mr Justice MacDonald.
Yes.
You say, well, there should still be a self-denying ordinance, recognising the fact that really there needed to be habitual residence at the first stage.
Well, if my lord is considering how things were when they were before Mr Justice MacDonald, he found there was habitual residence at the date the case was before him
Yes,
and proceeded on that basis.
yes,
He, if I put it this way, as good as found that if he'd been asked that question in, say, September or December, the answer would have been different.
yes.
And that, as he put it, the case may very well have taken a different course.
But I think a moment ago you were explaining, well, even supposing there is jurisdiction in a strict sense, because of residence at the earlier stage or whatever, because there wasn't habitual residence earlier, the court should be self-denying. That's not quite what you were saying.
That looking back on it, if things had proceeded, as I'm sure it's by common consent they should have done, with a speedy determination of question 1, where is H habitually resident? And if that question had been, well, not here, in Tunisia, then on my lady's proposition, which is also our second level proposition, there would have been proceedings in being. They would have been primarily Article 11 proceedings, but they would have utilised powers under the Children Act that might have necessitated the Children Act application remaining in being. But because the court would have determined there wasn't habitual residence, the court might have been different in the directions that it gave and in its pursuit of the future for H. Hence, says Mr Justice MacDonald, the way the case would have turned out may have been different. If, on the other hand, as has unfortunately happened in this case, in July 2022, Mr Justice MacDonald decides that at the moment of determination there's habitual residence here, then all that he does is to say, fine, in that case I am seized of standard public law proceedings. The standard jurisdictional basis of habitual residence is made out. There's nothing bettered about that.
I'm probably misunderstanding. I thought in discussions with particularly my lady, you'd got to the point where, well, maybe the court did in a strict sense have jurisdiction even without habitual residence. Then the matter comes before the court, and I think you referred to the court being self-denying. Supposing that there was jurisdiction in the strict sense because there had been residence, the residual jurisdiction. Supposing come the hearing before the judge, you have habitual residence, such that the local authority could immediately institute new proceedings. Why would it be appropriate to be self-denying?
I think, and I hope my lord forgives me, I think I'm with your lordship now. It was the word residence that slightly spooked me.
Sorry, presence. And you're quite right. Yes.
It's completely different.
Yes.
If my lady's testing questions for me were, what would have been the position if, which is not admitted here, that's an issue under ground 2 and under the respondent's notice, if, let us say, the court had said in September 2021, there's no habitual residence here. There is an emergency jurisdiction which can be exercised. Article 11, reference to powers under the Children Act. But if the court had gone further and said, and what's more, if there isn't habitual residence-based jurisdiction, there is a substantive residual jurisdiction based on the common law which allows care proceedings to be pursued. Well, that's a very different scenario because it's not one that happened at all. In this case, if the answers to the points on grounds 2 and the respondent's notice by this court are different to what we invite, then one of the things which the court might say, possibly with all due deference, in giving guidance, is that there will be a cascade, and that if you have a situation like this, you will ask the question, is there habitual residence? If there isn't, and there's habitual residence in another state, which is a non-convention state, you will be bearing that very much in mind when looking at the future of the proceedings, and you will be quite resistant to going down a domestic road of directions for a care order. You will make emergency provision, but if there is a case that demands it and if the jurisdiction exists, there can be substantive proceedings with the objective of leading to a determination under the residual jurisdiction. That would also be a determination of jurisdiction. If made at that stage, everyone would know where they stood. Those who wanted to challenge it could challenge it. Those who wanted to know what the root of the powers used would know what the root was contemporaneously. So I can see, although I don't think any of the parties before the court have looked at it in that way, that if the court took a particular view, that might be a very helpful analysis to make in a judgment. Does that answer my Lord's question?
Yes, thank you very much.
Though of course it is not our case.
May I just pick something up, because I was going to ask you whether in a way what you're saying in those circumstances is what's required is firm guidance. So presume for a moment your ground 1 is made out and that the proper date for the habitual residence consideration was the date of the institution of the proceedings. You've got your Article 11 and presume for a moment that you accept that care proceedings by necessity are there. So you've got a judge who says, right, well, I've got a child that needs to be protective measures, I've got care proceedings, I've got information that would satisfy the threshold, but I don't have habitual residence. So I think what you're saying is that in those circumstances, the approach to the proper progress of the case must be, the judge must be strongly informed by the fact that the child is habitually resident in another country. It doesn't matter where, another country. What I just want to test with you is I think you said to my Lord Justice Newey something along the lines that they shouldn't be sort of rolling on towards looking for a care order. But of course, if you're right and we have that set of circumstances, the local authority is bound by the no order principle. And so they could plan and assess and look, but being heavily influenced by the fact that the child was habitually resident somewhere else, and that the proper resolution under the no order principle might be that the child goes back.
If I make the concession, which was built into my lady's question to me, that there is potentially,
and I understand you're only half making that concession,
presence-based jurisdiction, then yes, but it then becomes a matter for very strong case management.
Well, I can
But
see
again,
that. I can see
that case management can't be undertaken unless there's clarity at the earliest stage on jurisdiction.
No, well, that takes us all the way back to, this is why you say ground 1 is critical,
Yes.
to a proper welfare based determination for a child.
And I would, as with the delicate caution offered to me by Lord Justice Moylan, it's not just habitual residence that has to be determined at the earliest date, it's jurisdiction. And so if there are alternatives, those alternatives are likely to fall to be considered. So, my Lord, my Lady, and my Lords, that is our observation about the merits, and their legal merits, as well as policy merits of our position on ground one. They're bolstered, we say, by the emphasis in the 1996 convention, and indeed in the practice guide, on a concentration on what happens in the jurisdiction of former habitual residents and to proceedings in that jurisdiction, where, of course, the absence of perpetuatio fori means there has to be a focus on what happens there. There is not the same detailed focus, and certainly nothing, we say, which dictates a procedural approach on what happens in the country where habitual residence is acquired. That, we say, is entirely a matter. And there the proposition that my Lord Justice Moylan put to me, and which I accepted, comes into its own in support of our case. That is to say that there is nothing in the 1996 which purports to dictate particular aspects of the domestic jurisdiction. What we say is the starting point for proceedings, and when we say the test should be exercised, is entirely a matter for us. And going back to Section 7 of the Family Law Act, the concept of a relevant date, and that date being the start of proceedings, the date of the application, and there's undoubtedly an application in public law proceedings. It is the issuing of the Section 31 application, is the appropriate approach, and it is with great respect, although well-intentioned, essentially unprincipled to depart from that and hang the departure on what is not in fact a requirement of the 1996 and the perpetuatio non fori. No, I'm wrong. It's not a perpetuatio non fori principle. The absence of perpetuatio fori in that convention. But can I do what I promised to do for ages now and come to the counterbalance, which is how things work on Mr Justice MacDonald's scenario and on the submissions of my learned friends.
Sorry, I have one question before you do. You say it's not a matter for the Hague Convention, but Article 5.1 says that the states which have jurisdiction are the states where the child is habitually resident.
Yes.
It doesn't actually use the word is. The judicial of the habitual residents of the child have jurisdiction. So that's the foundation of jurisdiction. It doesn't say the date, I appreciate that, but clearly if each, and I know in different states, for example, as pointed out in the skeletons, Australia has got quite complicated domestic law provisions as to the application of the 96 Convention.
And Switzerland has also got its measures.
And Switzerland, and we don't, but that is the foundation of jurisdiction.
That basic principle is it is indeed. But my Lord,
And you're saying that has to be determined immediately, because otherwise the state doesn't have jurisdiction to take measures directed to the protection of the child, apart from Article 11.
or such other jurisdiction
As might
as the
exist.
court
Yes.
determines.
But I was just saying Article.
Can
I assumed the foundation of your argument was actually Article 5.1.
Is Article 5. Indeed it is.
Okay.
But my Lord, again at the risk of going down a byway, in the consideration of Article 15 of the Brussels II revised regulation, which led to the hearing in the Supreme Court in Re-N, one of the key distinctions highlighted in the Court of Appeal by Lady Justice Black, as then she was, and then taken up both in the Supreme Court hearing and in the subsequent Court of Justice hearing, is this. The word is jurisdiction, but it's not proceedings or the matter, and they are different things. And what the 1996 by Article 5 deals with is a matter of principle on the allocation of
Yes.
a territorial jurisdiction.
Yes.
Whereas what happens in proceedings and the law and rules on proceedings are absolutely not dictated by the 1996. They are a matter for this court. Let me now, if I don't do it now, I suspect I simply never will, come briefly to the position in respect of Mr Justice MacDonald's approach.
The rolling jurisdiction consideration.
That's it. Made all the more a never-ending rolling stream by the interesting submissions before this court on behalf of the Guardian, who says, well, in effect, there's got to be a constant watching brief in proceedings to see what's happening. And it relates, of course, to loss as well as gain. We've been thinking in this case, because it's what's engaged, about gain, not loss. I would have to concede that there is much more concentration in the 1996 and in particular the practice guide on a focus on what happens in the country that loses jurisdiction than in the country that potentially gains it. First of all, my lady and my lords, you can have a transfer of jurisdiction without it having any consequences in proceedings at all. Because in the case of an innocent child and innocent parents who've not got into any engagement with the courts, a consensual transfer of country by a relocation, a lawful relocation, will result in a change of jurisdiction, but it's not, of course, going to result in any need for proceedings to start. If there are extant proceedings, whatever their description, then there will be, as we've said, an eligibility for those proceedings to be beefed up by the addition of habitual residence as something which adds an aspect to the jurisdiction. It may, in some circumstances, allow a different form of jurisdiction to be instituted and then exercised. But what Mr Justice MacDonald has done, with great respect to him, is to allow that in those cases which are bad, deprecated practice, but nevertheless, as I know the court will agree, far from exceptional, there is a long delay, a substantial delay in which much happens between the institution of the proceedings and the determination of habitual residence. If, as in this case, the determination of habitual residence sanctifies, ratifies the proceedings which have not otherwise been justified at an earlier stage, then in effect, though without having said so, it has retrospective effect, and that is deeply unsatisfactory as a matter of principle. What is said in support of the MacDonald approach, if I may so call it, is that it is infused with welfare, because how can it be other than right that jurisdiction should reflect the welfare position and the welfare needs of the child on a contemporary basis? It's a very persuasive argument in a jurisdiction like this, in which what we do in children's cases, the checklist under section 1.3 is amended under the Children Act 9 emphasises it. The old principle of paramount welfare preceded it. We've got a long and honourable history of saying welfare is paramount, but not, and here we agree with great respect with Ms Renton, not when it comes to technical matters like deciding whether or not there is a jurisdiction and whether and upon what basis that jurisdiction exists. Welfare may influence that if it's a question of exercise. It may influence, subject to my manifest caveats, whether and how a residual jurisdiction is exercised. But it can't allow the court to play, with respect, fast and loose with the precise questions and the discipline of timing in terms of determining jurisdiction. What Mr Justice MacDonald has said, and I know that those who prepared the local authorities discussion said there was a confusion in our case on ground 1 because we referred to two things. We referred to the date of the institution of proceeding, 18th of August. That's our primary case. But we also referred to the listing of the application with regard to the determination of jurisdiction. The court had an explanation of that in our skeleton. It deserves, and perhaps my learned friends, if they pursue the point, deserve a very short explanation now. Mr Justice MacDonald, in the usual way, distributed a draft of his judgment. He received some submissions. He then put out the judgment in its approved form. Of course, it's only the judgment in its approved form that this court will be interested in. But between the two, there was a change, and it related to the precise point in time at which Mr Justice MacDonald took the view that habitual residence, the snapshot of habitual residence, was appropriately taken. If it had been when the investigation into the issue was listed, that would have been December, at which stage there's abundant evidence that habitual residence would be likely to have been still not here, but in Tunisia. What happened when the judgment came out, which we informed Mr Justice MacDonald of as part of the general duty we have to assist, was that those members of the bar who are numerous, who specialise in international cases and international public law cases, had cottoned on to the wording of the judgment and had thought, aha, if we say that the issue of jurisdiction listed on a particular early date is then part heard until it is determined, by that artifice we will be able to avoid a contemporaneous decision, which might of course be adverse to one party. We raised that before Mr Justice MacDonald because it was plain an abuse and it was not what was intended.
Was this arose amongst the international bar as a result of breach of an embargo of the draft judgment?
No. This is what arose. There was no breach of the embargo, I can assure my lady. This
I wasn't accusing you of handing out the judgment.
This arose.
I just couldn't understand how this had come about.
No. This arose from the wording of the final judgment as released. I don't have time to make arrangements for my defence on a committal charge. It won't arise. Absolutely
get
not.
legal aid, Mr. Setram.
Absolutely not. So it's because of the way the wording he used came about, and so it was clarified in the second judgment.
Yes, I recollect that.
And what in effect it now means is that logically, until I could use an unsavoury operatic analogy, but until the judge gives his or her judgment to say, and I determine that habitual residence is, absolutely until that moment, things remain fluid. So it's not when the proceedings are started, it's not at the first directions hearing, case management hearing, it's not when the issue is listed, it's not even necessarily at the beginning of the hearing, which could indeed go part heard, notwithstanding the implications to be quick on habitual residence. And so what it does mean is that there really is a moving target. Although Mr Justice MacDonald, as one would expect from the Deputy Head of International Family Justice, whose work in coordinating, in having an input into practice guidance, and his assiduousness in cases of this kind is really second to none among puny judges. He made the usual blood-curdling imprecations about the need for speed and resolution in getting on. But nevertheless, in those significant cases where it doesn't happen, what he achieves is a high degree of fluidity and uncertainty, which simply helps no one. And it doesn't help the child, because if the child, and here's the counterpoint to the local authorities and the guardian's case, because one of the things that they've said is, well, how does it make any difference? How does it make any difference now that Mr Justice MacDonald waited, didn't wait, it took until July 2023 to decide the point. It made a difference, not only because the party who was subject to the orders, the parties who were subject to the orders, didn't know the jurisdictional basis on which they'd been made. I've done that one to death, I won't go on with it. It also meant that there was a loss of a chance for the child and for the aunt to enjoy the benefit of the coloration, putting it at its very lowest, that a determination that habitual residence was in Tunisia would have had. And perhaps the pursuit with more urgency of the views and input of the, I think I said the aunt again, of the grandmother.
We know who you meant.
I'm grateful. It would almost certainly have resulted in a much more energetic approach to the pursuit of an input by and the views of the grandmother. It could scarcely, with respect, have been less energetic, unfortunately, than it turned out to be. And that there would have been an engagement with the Tunisian authorities, and we know that social services have been involved in Tunisia, and we know that the Tunisian government, so at a high level, the Tunisian state is motivated in this matter. And all that could have been done, and the outcome might well have been different if Mr Justice MacDonald's approach, the best will in the world, is allowed to remain, then there is a measurable risk that injustices will be done and that there will be an imprecision in the operation of the English jurisdiction. In the end, it inures entirely to the welfare of subject children that these matters are sorted at the earliest opportunity. Apart from anything else, the usual delay provisions in public law apply, because the court needs to know where it is going and why from the earliest opportunity, rather than waiting 11 months to see what the jurisdiction might be. And as we have seen, even after those 11 months, there's the possibility that that wouldn't resolve jurisdiction entirely. If, for example, the determination was that there wasn't habitual residence, what would the court then do? It would look at the other jurisdiction. I needn't go there, but without going into the, I don't say florid, but the colourful policy points that have been made, which we've made about uncertainty and manipulation, which have been made very helpfully by the IAFL in their submissions when they talk about international certainty, predictability, the obvious desirability of being able to advise litigants. And leaving aside also, though I have mentioned this to my learned friends and to my lady and my lords earlier, the possibility, which I invite the court to have in the back of its mind when formulating a judgment, about a carryover effect, perhaps an inadvertent carryover effect or influence, in cases other than public law cases. There is a cast iron case, we say, for sticking to the relevant date as the date of the application. So, my lady and my lords, that's our position on ground one, which is the principal thrust of our case. And so, if I'm allowed to turn to Miss Guha.
Can you just, sorry, before you do,
Yes.
this is what I was, the relevant date. So the different situations are no jurisdiction, can I put it as broadly that, the date the proceedings are commenced, but the acquisition of jurisdiction during the course of the proceedings and the other way around, including both in respect of non-contracting states and contracting states. So that the court's response might be different depending on which, I mean, taking your point that the court should be determining whether it has jurisdiction at the earliest possible moment. The court's response might be different to the acquisition, what to do if the court doesn't have jurisdiction at the outset but acquires it during the course of the proceedings, as to whether the other contracting state in which the children were habitually resident at the outset of the proceedings, the other state is a contracting state, and it isn't. Is that...
There might be
In other words, the approach taken by Mrs Justice Leven might be the appropriate approach in a case where the other contracting state, the other state was a contracting state and saying, do you want to transfer jurisdiction? Whereas that isn't available in a non-contracting state.
It isn't available in the codified form.
Yes.
That it appears in Articles 7 and 8. There may be a difference in the way things proceed.
So what I'm...
But that's not a question of...
No, I understand. But it's... When you were saying for guidance, I think it might be quite difficult for the court to give guidance covering all these points, because I think they would need to be separately argued. But I think what might support the force of your submission is that the court has to determine whether it has jurisdiction at the commencement of the proceedings, is because that might have a different impact if the other state is a contracting state, because the court might say, well, actually, we should, first of all, are the proceedings in the other state? Because there are, we should stay the proceedings. If not, do we want to invite the parties or the relevant public authorities to start proceedings in that other state, or just to find out? So that's why I'm saying it might, to create what you're saying, a proper structure to the determination of the issue of jurisdiction.
With respect, yes, my lord, and it's rolled together with the other observations that we've made about the different course the case would take with an experienced judge in the driving seat. There are, of course, numerous different varieties of state and almost endless different factual scenarios, and there are surrounding them all sorts of potential issues, taking my lord's point absolutely, that giving guidance that is too specific may be exceedingly difficult. There will be the cases of children who have been brought here in flight from something in the other state. There will be cases where there are concurrent asylum claims. There will be cases of states convention or non-convention which are regarded as exemplary actors in this country, and there will be cases of states non-convention and perhaps even convention where there is a suspicion about those countries. But having been informed about habitual residence will enable the court not only to decide where it should go on jurisdiction subject to what is available, but also, exactly as my lord said, to look at what should be pursued and how it should be pursued. We venture to suggest that in the instant case, where a court of a convention state, that is France, had placed this child with the grandmother in the non-convention place, Tunisia, with the involvement of social services, and where the Tunisian state was involved and enthusiastically advocating a return to Tunisia, that some very proactive engagement would, in this particular case, have been called for.
Well, except that
I'm
that
going
can-
beyond
yes.
my remit, my lord.
And that connects with your application for a summary return order. What jurisdiction was that being made under?
Yes, lord.
What jurisdiction were you inviting the court to exercise?
I'm going to check with my learned junior. I think I know the answer. But that, of course, to answer the underlying point first.
No, there's no underlying.
Yes, there is.
That's right.
The underlying point is that it was not designed to place the child in the care of a person. It was designed to achieve a summary return. And that is an area where, incontrovertibly, we say that complementing the 1980 Hague Convention for non-convention cases, there is a jurisdiction. But let me pass
Yes.
to my learned
Yes.
friend, having answered that part of the question, to see. What was it? Thank you. Inherent jurisdiction law,
Okay.
as it would.
Well, no, because in Re J,
Yes.
they decided that a return order could be
Yes.
an Article 11 order. But you were not inviting the court to exercise that. You were inviting the court to exercise its inherent
It was
jurisdiction.
an inherent jurisdiction. But I don't think we got so far as to argue the precise, and I hope we can be forgiven for that, the precise basis of jurisdiction.
Yeah,
No
but it's
one
relevant
challenged.
to your issue. It's relevant to what jurisdiction does
Yes,
the court have.
it is. It's one of those jurisdictions that is probably a jurisdiction of necessity. I've already indicated.
Okay.
I've
Yes.
already indicated how it is not the sort of order that is encompassed in the considerations of, for example, Section 11D Brussels.
No, but if you're talking about the inherent jurisdiction, you're talking about the parens patriae jurisdiction, are you?
We are probably talking about the statute, the Superior Court Act. But, my lord, I don't think we looked into it.
Okay.
I have to.
No, don't worry.
in
Because
any depth.
because the parens patriae is British nationality.
That's right.
So,
That doesn't apply.
yes.
And couldn't apply
No.
in this case. And that is something I'm very grateful to your lordship, which I should have mentioned. That of course, that recourse to an escape from an absence of regulation or convention jurisdiction wasn't and couldn't be available in this particular case. Your lordship is, with respect, quite right. We could have sought to use Article 11 because that a return, and it's been argued, it was argued under Article 20, is a quintessential use of an emergency.
Yes. It would still be the welfare jurisdiction. In other words, the
powers
court
of
would
welfare
the court would still be, as Mr. John, I think MacDonald said, applying the NY
Yeah.
approach to the issue.
And welfare.
Well, that's right. But,
Yes.
yeah. Okay, thank you.
That was the root of that. Yes, indeed, my lord. And the other point, I suppose, that I could make, which also would have made a difference, if there was a determination that there was habitual residence in the other state, then it would predicate or encourage, surely, a prompt application for just such a return if the, as we can properly call her in this case, the left behind person in the position of a parent was energetically alerted and given the opportunity to take part in the proceedings.
Well, yes, except that she knew the child was here
She did.
and didn't and didn't, as far as we know, seek to engage, to find out. I mean, it's an observation, it's not a criticism, it's just saying there was no proactive, doesn't appear to be any proactive engagement in seeking to find out what legal steps might be open to her in this country.
Everything that we know suggests that from the start, the grandmother has been anxious to achieve a return. But where there are proceedings launched by a public authority,
yes, I see.
in a public authority,
yes,
of this nature,
thank you, I
there
understand.
is a very high obligation, which regrettably, I don't wish to lay blame for it, was not met, and it was not until the spring of...
No, you've said...
So, my lord is technically right.
Yeah.
That might be
No,
not a little harsh,
yes,
if applied to this case.
yes.
So now I'm going to turn, if I may, to Miss Guhart,
Of course.
and see if I can move on to the other ground. Any other points there? Thank you very much. Yes. So, can I move on, and necessarily perhaps slightly more shortly?
Well, I think you've interwoven a lot of your submissions.
I think that's right. I think that my lady and my lords know more or less what we say about ground
Yes.
2, but what we suggest hasn't been sufficiently catered for in the careful observations of the local authority and of the Guardian, and to an extent in Mr Justice MacDonald's judgment, is the extent to which, logically, the existence of the 1996 Convention and our signatory status as a member state of that convention, and our faithfulness, therefore, to the fundamental principles which my Lord Justice Moylan rightly identified as important and taxed me if I gave the impression that I didn't think that they were. They're vital. How consistent is it with a serious and faithful approach to those obligations to maintain a jurisdiction which doesn't accord with the Article 5 principle? If it is a jurisdiction of necessity, and I know that my lady and my lords are utterly familiar, and not only in the context of Public Law Children Act proceedings, but also in the context of children proceedings, family proceedings generally, court of protection proceedings, all sorts of proceedings. The inherent jurisdiction is something which used to be used with relative abandon and without much thought being given to it, and people, sadly like me in the 1980s, used to tip up before a court and make all sorts of applications under the inherent jurisdiction. We wouldn't dream of doing now. the statutory development of statutes has gradually eroded the use of the inherent jurisdiction. The Children Act 1989 did it in terms of family proceedings. The Mental Capacity Act 2005 did it in respect of proceedings in the new Court of Protection. And one has to work very hard to justify using the inherent jurisdiction. I know I'm using that as a technical jurisdiction, and my Lord Justice Moylan rightly said, what inherent jurisdiction is that you mean? And Sir James Mumby was equally assiduous in looking at that. But I use it as an illustration that Section 100 of the Children Act, which dates back to the inception of that Act, in force in 1992, is now reflective of a very much more aggressive approach to minimising the use of an inherent jurisdiction. If one is looking at a jurisdiction which, during the long reign of Brussels 2A, was very heavily restricted in all classes of family proceedings. In this era, after the end of the transitional period, will there be a view taken that there can be a recourse to a judge interpreted, substantive jurisdiction, the residual common law jurisdiction in Children Act cases, if it exists, which can be used in situations other than that of urgent necessity, which would be otherwise covered by Article 11? Or can a case be made for such a jurisdiction to be used in a more general way, and frankly, for the determination of proceedings, the end of which is designed to be the placing, potentially, taking the no order principle, of course, but in the end, an application for a care order is an application for a care order. That's part of the catalogue of orders that can be sought. Can that be justified without having a particular basis for justifying it if, and it only operates if there's no habitual residence, if it appears to operate contrary to the thrust of Article 5. That's never been tested in this case, though Mr Justice MacDonald gave his view, but it was genuinely obiter because he never had to go down that road. We felt that we had to appeal on that ground because we don't want to be unrealistic, and the court could throw back at us, well, if you run your first line, ground and leave it at that, where does that leave you if you don't challenge the second finding? So we do. So there are the questions which are stratified, and I, without derogating from the earlier positions in which we make no concession and invite the court to give a view, we feel much firmer ground when we look at what the position would have been in terms of a recourse in another jurisdiction if promptly Mr Justice MacDonald or another judge had found that there was habitual residence in Tunisia. What would have happened? Why wasn't it looked at earlier? What was the loss, quite considerable, we say, to our client of the child? And in the circumstances of this case, in line with his determination in the judgment, what are the criteria for having recourse to whatever jurisdiction it is? Is it simply an emergency jurisdiction on the one hand, or on the other hand, is it one where if there is a presence here and habitual residence in a non-convention state, does it follow almost as night follows day that the court can have recourse to it? What is the guidance that judges need when looking at that, and by what stages should they do it? My Lord said, I think, that the grounds are interlinked, and indeed so they are, because just as a court which had informed itself of the position on habitual residence early on and had determined that habitual residence was in Tunisia, would have been able to decide with energy and immediacy what were the other jurisdictional recourses and what use it would make of them. So the delay has helped nobody. I don't know whether there is anything more, and I'm going to, that cuts 32 pages of helpful opening notes down in this section at least to some concluding thoughts. But subject to my learned friend, I do think that the court probably has our case, and I will be able to reply on that. I wonder whether, subject to Ms Guhar, and I will turn to her, I can use the last few moments of the morning in making some bullet points on the respondent's notice, or whether that is better left. I said that we were all agreed we'd finish today. It's now a slightly finer run thing than it was, but I think that if my learned friends keep to their estimates of time, I will still have half an hour for a reply.
You may not need half an hour, let's wait and see. May, but you may not.
Thanks. Well, may I have a moment? Anything? The one point which perhaps deserves reinforcement that Ms Guhar would like me to make in summation of that point is that given that the 1996 Convention seeks to set out, and we can take comfort from the non-convention state provisions of Article 11, a uniform jurisdictional regime, that surely must have very great weight in any divergence from that regime in the manner asserted by Mr Justice MacDonald and supported by my learned friends. So that, my lady, is that. I'm not sure that I do have much opportunity now, realistically, to give our bullet points on...
Well, while you were taking instructions and discussing this with your junior, we had a brief word with each other, and we'd rather wait and hear your response once you've heard what
Thanks.
Mr. Junior.
In that case, that is my opening.
Thank you very much indeed. We have no questions, thank you. Very well, shall we resume at 2 o'clock, please?
All rise.